criminal antecedent to enter politics, enter the precincts of Parliament street cliche, and the number of such people will surge, increase, or expand instead of being truncated or brought down. So, my lord, I appeal to your lordship, lord, that the minority judgment, my lord, maybe.
Thank you, Mr.
Lord,
Thank
there
you.
are, my lord, may I just say this, my lord? Lord, the additional submissions which have been made, my lord, there are 4 councils who wish to address your lordship, lord, which is in volume 8, my lord. There are four councils which have said. Lordship may give 5 minutes to each of them, my lord. The 4 councils who have said, my lord, in that order only, my lord. Ms. Kalita, Dr. Sharma, Mr. Banduri, and Ms. Karyawaj, however, my lord. Lordship may. Huh? I'm saying that let it be in the same order. That's what it will be easier.
Yes. Mr. Bandari, you want to speak? We'll hear Mr. Bandari for 2 minutes and then we
Yes,
can.
Your Lordship. I would take 2 minutes of Your Lordship time.
All right. Yes,
and I'm
sir,
grateful to Your Lordship. Your Lordship, my submission, I have given a short submission, Your Lordship, in volume 8, page number 3 and 4, volume 8. Your Lordship, my humble submission would be that the parliamentary privilege, Your Lordship, I would wish to read from my note.
Just one second.
Your Lordship, Justice Narasimha has.
Yes.
Yes. My humble submission, Your Lordship, is that the parliamentary privilege and the immunity that are conferred on the members under Article 1052 and 194(2) of the Constitution of India for smooth functioning of the Parliament, so that they can vote and speak without any fear, which has been quoted in State of Kerala versus Ajit, Your Lordship, which is referred in volume 5 of page number 2996 of para 44. Your Lordship, it is respectfully submitted that such privilege has to be read in consonance with the basic structure of the Constitution of India. And if the privilege is treated in an absolute shield, then the very essence of the democracy for the protection of the rights of the citizens will be lost. Therefore, Your Lordship, the legislators are the citizens' representatives and the work for the welfare of the people. And therefore, they are the lawmakers and cannot be the lawbreakers. Secondly, Your Lordship, my humble submission is that the reason for grant of immunity in respect of anything said or vote given was to ensure that inside the House, the statement made should not be criminally punishable. But today, Your Lordship, this privilege has taken the color of criminalization, and the provision is being misused under the cover of broad interpretation given by the majority of the judgment in the case of PV Narasimha Rao. Your Lordship, my humble submission is that the immunity was never intended to place the parliamentarians at the higher pedestal and the grant immunity to them, no matter how grave or the criminal their acts might be.
You're adopting the minority's test of arising out of.
Adopting the view. And Your Lordship, therefore, if the members of the Parliament have done unethical acts and otherwise contrary to the law, which is out of the periphery of the discharging their parliamentary duties and responsibilities, then they should not confer the immunity.
Thank you.
And thirdly, Your Lordship, in respect of Your Lordship, the term, the interpretation, Your Lordship, in respect of should be interpreted to mean arising out of, and therefore it should be purposive interpretation, limiting the immunity granted under clause 2. Now, only those acts and the words were said
we'll have a look,
House,
thank
which
you.
also include mere participation, Your Lordship.
Now, the next submission we have was of Dr. Vivek Sharma, right?
Grateful, Your Lordship.
Thank you. Thank you.
Volume 8, page number 6, sir.
Volume 8, page 6,
Page number
right?
6, sir.
Right. Let's see what you have
To
said.
decide the basic issue, the immunity from the criminal prosecution involved in this case, 3 points should be kept in the consideration. What was the intention of our constitution makers under Article 105 and 194? And the second point is that whether in democracy a voter can expect from his elected representative that he should be allowed to take money or bribe for speech or vote in the House. The third one is whether immunity from the criminal prosecution for taking bribes, money for vote or speech in the House to MPs, MLAs is creating the different class who are allowed to corrupt the basic foundation of the democracy. In a healthy and honest democracy, elected representatives is for the service of nation. There is no place of immunity for taking bribes or cash. And the last one, and the D point is that our constitution makers took the different provision of the constitution from the word democracies according to Indian perspective. They borrowed parliamentary form of government from the United Kingdom, but they did not accept it, the parliamentary supremacy. Their ideals and aspirations are very high for the newly born Republic of India. Our constitution makers never wanted that. By the virtue of privilege under Article 105 and 194, the lawmakers would seek criminal immunity from the bribes. It is not only the immoral, but also destroys the basic structure of the democracy. Today, lawmakers would take bribes or money for vote or speech in the House. Tomorrow, the voters would take money for the vote. Then what would happen? Certainly, there is no place for immunity from criminal prosecution for taking bribes or money for vote or speech in House to MP and the MLAs. So the minority statement in the PV Narasimha Rao case, I think so.
Thank you, Doctor. Yes, Mr. Bhandari.
I'm going to take very briefly, Milods. I think the debate has surrounded Milods, and we've looked at it from a perspective where we are all looking at it as a person, as a parliamentarian who accepts some money before he walks into the parliament and votes in a particular manner. But Milods, there will be a large number of permutation and combinations. There could be a parliamentarian, Milods, who takes no money, walks into the parliament, votes in a particular manner, but comes out and then after that takes certain illegal gratification. So while, yes, Milods, I support as an intervener that the cloak should be trimmed, but Milods, how far it should be trimmed and what should be the boundaries is something that this court should endeavor to set it out. Now, the minority view in Narasimha's case and the majority view both look at American jurisprudence, both look at the Brewster's judgment, which has been read to this court. The minority, Milods, when they look at Brewster's judgment, they come out with a test that it should be an essential and integral part of the cause of action. Now, Milods, to say that it should be an essential and integral part of the cause of action would leave, Milods, a lot of parliamentarians, Milods, to prosecution, would be my humble submission. And therefore, there needs to be a far more rigid test that needs to be propounded and needs to be laid down. Because, Milods, we in a Westminster form of parliament are not only, Milods, parliamentarians don't necessarily belong to a big political party. We have to also ensure that the cloak is strong enough to protect, let's say, an independent member of parliament. So therefore, when a cloak is being trimmed, there should be some checks and balances to ensure that false prosecutions and prosecutions which necessarily penetrate the cloak and starts looking into what the parliamentarian did in the parliament should not be allowed. Now, Milods, this, according to me, this test which is propounded in the minority judgment of Narasimha, Milods, is actually, Milods, in tandem with all the judgments in the US. Now, Milods, before Brewster came, there was a very important judgment, Milods, called Johnston. And Johnston has been critically, Milods, analyzed in the American jurisprudence as saying that it gave too much of protection to parliamentarians. However, Brewster, Milods, did not overrule Johnston, did not say Johnston is wrong law, rather explained that Johnston was right law. Milods, I just wanted to show you one or two paragraphs of Johnston's to show that really, even if one looks at Johnston, which is seen as a very restrictive case, still the test propounded there would also work in our Indian context. Milods, Johnston is item number 13 in volume 5A. Item 12, Milods. It's page 202, it starts in volume 5A. Interestingly, Milods, Johnston's notes that the reason this whole immunity came was not only to save the parliamentarians from the crown, but also from the judiciary. And way back, the more fear was the judiciary acting at the behest of the crown. And that's why this protection came in. So, Milods, the reasons might be quite misplaced in today's times. And therefore, Milods, those reasons may not apply. But, Milods, I don't want to take the time of the court because I know I'm on very limited time. I don't want to read why the protection was given, but it's very well explained at para 3 and 5 and 6. But, Milods, I want to come to straight at the test. If I can read para 15, Milods, in Johnston, because Johnston's is seen as something which is far more expansive and gives more protection to a parliamentarian than what he deserves. Let's page 205, para 15. In the same vein, the government contends that the speech or debate clause was not violated because the gravamen of the count was the alleged conspiracy, not the speech, and because the defendant, not the prosecution, introduced the speech itself. Whatever room the Constitution may allow for such factors in the context of a different kind of prosecution, we conclude that they cannot serve to save the government's case under this conspiracy count. It was undisputed that Johnson delivered the speech. It was likewise undisputed that Johnson received the funds. Controversy centered upon the question of who first decided that a speech was desirable, who prepared it, and what Johnson's motives were for making it. The indictment itself focused with particularly upon the motives underlying the making of the speech and upon its content. I won't read the charge, my lords. In para 16, we hold that a prosecution under a general criminal statute dependent on such inquiries necessarily contravenes the speech or debate clause. We emphasize that our holding is limited to prosecutions involving circumstances such as those presented in the case before us. Our decision does not touch a prosecution which, though as here founded on a criminal statute of general application, does not draw in question the legislative acts of the defendant member of the Congress or his motives for performing them. And without intimating any view thereon, we expressly leave open for consideration when the case arises a prosecution which, though possibly entailing inquiry into legislative acts or motivation, is founded upon a narrowly drawn statute passed by Congress in the exercise of its legislative power to regulate the conduct of its members. So, my lords, here the court clearly says it does not touch upon a prosecution, though as here founded on a criminal statute of general application, does not draw in question the legislative acts of the defendant member of the Congress or his motives for performing them. So, my lords, the issue is not what he did when he entered the parliament. What speech did he make, who prepared it, and how he prepared it, and how he delivered it, and how much did he emphasize on certain aspects of his speech in favor of someone. What matters is what he did before entering into the parliament, or what he did after he exited the parliament in pursuant of a criminal agreement for illegal gratification. So whether the bribe is paid before or after would have no consequence, because that act would not be actually looking at the content of the speech. The court, my lords, in Brewster, then, my lords, says at para 39, at page 216, and this is, my lords, I think the aspect that comes out. Brewster doesn't say that Johnston is bad law. It explains Johnston's by saying that the prosecution should be able to make good the charge without asking the prosecution to adduce evidence as to what happened in the parliament. So it does not matter, my lords, how he voted, because even a bribe taker, my lords, may cheat the bribe giver. But that is not the gravamen of the offense. The offense is that he agreed and accepted to take a bribe. Section 7 of the Prevention of Corruption Act, my lords, of our country does not inquire whether actually the bribe taker did perform what the bribe giver asked him to do. The fact that he agreed to do something is good enough for the offense to happen. Therefore, one does not need to look into what happened inside the parliament. And that is where should be the, my lords, the hard boundary. That can the prosecution make a charge and take it good to the end without looking into what actually happened inside the parliament? What was the tenor of the speech? Whether he voted in a particular manner or not, or whether he abstained from voting or abstained from voting. If that is the test, that whether prosecution can be brought in without scrutinizing the act inside the parliament, my lords, within the confines of the parliament, then, my lords, according to me, that the cloak would be good enough to protect what its intention was, to protect the freedom of the parliamentarian. And, my lords, para 39 in Brewster really catches that.
Yes.
Para 39 and para 62 in Brewster catches that. So, my lords, even judgments in the US, which have taken a slightly different view from Brewster, have been reasoned. And, my lords, the last judgment, I'm not going to read it, my lords, but where, which was not cited in Narasimha, it was actually there at that time, which considers both Brewster and Johnston, is in, my lords, volume 6, which is very important. It's McDay, my lords, US versus McDay, which is, my lords, the relevant paragraph is at page 294, where the court says that yes, prosecution can't bring in the evidence as to what happened in the parliament. Prosecution has to make its case good on what happened outside the parliament to bring home a charge, but the defense can. So, my lords, it will not stop a parliamentarian to show, oh, you are charging me for corruption, but actually I did not vote in such a manner. So he might be able to bring in. but the prosecution cannot. And that is where the test should be. I'm deeply obliged.
Thank you, Mr. Bhandari.
If I may please, my lords, the submissions, my submissions start from page 22, volume 8.
Yes.
My lords, my submissions would be limited to the interpretation of the term in respect of. My lords, clause 1 of Article 105 confers freedom of speech in Parliament, subject not only to other provisions of Constitution, but also to rules and standing orders regulating the procedure of Parliament. Thus, the freedom of speech is not absolute, but is subject to various other provisions as has been mentioned in the article. My lords, clause 2 grants immunity to the members from proceeding in any court in respect of anything said or vote given by him in Parliament. My lords, my humble submission is the first part of clause 2 has to be juxtaposed with the second part and cannot be read in isolation. They both have to be read together. Further, my lords, the term in respect of cannot be colorably exercised by parliamentarians to cover within its ambit of being involved in any act or conspiracy or crime outside the walls of the House. There is no reason to grant complete immunity by interpreting the word in respect of to mean anything that relates to or concern or have connection with or nexus as held by majority judgment of Honorable Justice Bharucha. My lords, in point 3, I have mentioned that the expression in respect of is used in Constitution in 65 other places apart from Article 1052 and 194. And in PDF pages 24 to 27, I have attached a chart of those articles with the relevant provision. My lords, if the extraordinarily wide meaning is given to the expression in respect of, as per the majority opinion, the same would also apply to other provisions of the Constitution where these words have been used. And according to me, this would result in serious and grave consequences and may lead to incongruous results. Hence, such a wide interpretation should not be given. For example, my lords, I have taken in point 4, under Article 34 of the Constitution, Parliament may by law indemnify any person in the service of the Union in respect of any act done by him in connection with restoration of or maintenance of order in any area where martial law was in force. My lord, if an extremely wide interpretation would have the effect of indemnifying or granting immunity for all acts to that person when done during the martial law was in force, even if the same is not directly related to the restoration or maintenance of order. Similarly, my lord, if Article 122 clause 2 and 212 clause 2 would, if in respect of, would be interpreted in a wider sense, it would mean the immunity can be claimed even in respect of any action taken outside the House, which may relate or concern or have nexus with. So, my lords, my humble submission is that the expression in respect of must be interpreted to mean something that is intimately connected with the subject, immediately followed by the said words in respect of. It means something directly associated with or banded together or closely linked with the subject and not any remote nexus. Therefore, my lords, the majority judgment is in my humble submission in respect of should be limited and should not be given a wide interpretation. Obliged.
Thank you, Gautam. Now, anybody else? Thank you. All of you have formulated it well. All the juniors have really formulated it well. Yes, Mr. Kaplan.
No.
Has your
Read.
task become lighter or heavier, Mr. Patel?
Two written submissions. One earlier,
Have they made your task
part of
lighter
it
or
now.
heavier? Have all the juniors made your task lighter or heavier, Mr. Patel?
and there's a brief note which I had circulated in the morning. Before I take your lordship for that, but Master, today's morning note is it is there. Before I take your lordships for that, I mean, having been a part of the 239th and 244th Law Commission report, and having partly been author of the report and the concept note written about the importance of looking at criminalization of politics, I am personally has stopped from saying anything to the contrary. But apart from that, we are looking at a very, very important consideration of how do we deal with an ancient principle of law, that those who are elected representatives will enjoy certain protection. This principle of law has, if you gather all the constitutions of the world today, they are there in some form or the other, phraseology notwithstanding. That means that this principle is very important for one valid reason, that a person shall be free in the exercise of a function as a member of a legislative body without being impeded by any act of oppression or impairment. Probably those good old days when oppression of the executive was a very important aspect to be looked into. It may also undergo some forms, metamorphosis today. The executive cannot be probably directly impair a legislator's function, but it can devise various methods and, way of doing this oppression issue as we talk about it. Therefore, if the importance of ensuring that a person elected as a representative shall not be impaired and shall not be exposed to undue exertions or coercions. But at the same time, that the office of high trust being elected to a public office shall not be so exercised as to completely dilute the trust and the importance of the office. Then we are looking at how do we balance them. I don't propose to go into the question as to the minority versus the majority view, because if broadly speaking, all those aspects, in a way, a good part of my thoughts and ideas have been stolen and pirated by all my learned counsel of Arthur William. We can use these very strong expressions. But I'm trying to summarize why are we so concerned about it? It is a concern expressed by each and every one of them in different ways. But if you have to grapple with that concern and produce a norm, we are looking at the court. We're asking the court to produce or generate a norm which can probably interpret and apply in the application of Article 105 and 192. It's not really an interpretation. What we're asking the court is not really an interpretation, something beyond that. A mere interpretation giving meanings like whether the words any or in respect of, by giving such meaning, we are trying to clarify what is important provision the Constitution intend to convey is one aspect of the matter. But you want to go beyond that and say that the efforts made so far in various jurisdictions, the undertaking, the perspectives, whether in US or in Australia or in Canada. So I've also looked at, for instance, countries like Philippines, Czechoslovakia, and many of the European countries, where there's a report to the European Parliament on this question. There's the Transparency International looking at the issue of importance of public life being, on ethical and moral considerations. The same concern runs through all universally in all these places. So if you're talking about not merely an interpretation of any word or an expression in Article 105, but as I said, interpretations are probably not able to go beyond a stage where you keep on repeatedly saying, well, crime is punishable. Guilty outside, but not guilty inside. So if crime is punishable, then why can't it be said so? So if the court had to come and say that 105 does not contemplate, 194 does not contemplate commission of a crime, whether it is connected or in respect of or concerning, then of course the story is complete. So while the majority tried to grapple with this question, I don't think that they were not alive to the importance of reading 105 and 194 very correctly. They were alive to it. But they took a pragmatic view. They look at it from the point of, if you have to say something very radical about crime should be punished, which have nexus or no nexus, it will be punished. then it probably would require to some extent a rewriting of Article 194 and 105 in one sense of the term. Now, if you are looking at actions or proceedings or liabilities which may arise posterior to a conduct or speech or vote in a parliament, that's what on a plain reading of 105 and 194 it seems to protect, posterior to a conduct. And what the minority also tries to say that. So posterior to conduct, there is no difficulty at all. What speeches, what vote was given in the parliament, motives will not be inquired into. So what persuasions went to will not be inquired into. We're talking about something anterior to what happens inside and before the speech or vote is given. Then if that's what we're talking about, and then I am clearly the opinion that anything which is offensive under any law, proscribed by a statute, clearly proscribed by a statute, cannot have a refuge under the Article 105 or 194(2). I'm very clear about that. And I don't think any responsible government or any public authority can take a contrary stand. Let me take your lordships before I go further on this two-page note and then read my earlier written note. I don't think I need to trouble your lordships with the reading and rereading of all the US judgments. Because what emerged in the course of reading those judgments was the distinction drawn between external versus internal activities, legislative versus political activities. So lines are drawn probably to push the protection one way or the other. So what is a non-legislative activity for a person who is elected as a representative? To serve the constituency, you have to do a wide range of things. Brewster talks about it in paragraph 61 or somewhere. So are they protected? Of course, they will be protected as long as there is no criminal or unlawful dimension involved in any one of them. So the entire corpus of US law tries to look at that. But somewhere I find this clear line to be drawn, easy line that can be drawn between external versus internal activities can be somewhere problematic. That's I want to flag that. Because in that context, a whole range of work in the parliament depends on an information flow. So one of the cases US was talking about the mail fraud issue, where for the purpose of getting a particular legislation, you work through a criminal process and lobby. In US have a lobbying act. You can pay for lobbying, register yourself as a lobbyist. So we have all that kind of legislative proceedings which have tried to look at this issue from various angles. Therefore, the information flow is required for a legislator to act may sometimes involve getting unwittingly into a crime situation. That can be a trap. That can be something which it does not know. Therefore, these are considerations probably have to be taken very carefully before the court lays down a very inflexible norm as to whether anything which happens outside the parliament, beyond the speech and vote activity inside the parliament, anything which happens outside, which may have a tinge of or a shade of a criminal activity, will be questionable, could be a little broadly stated. I only want to have a little concern about that. Not that I want to say that crimes ought not to be, so they can't get the protection of Article 105. I'm not saying that. And then there are, as I said, the political versus legislative activity is also an important aspect. We try to draw distinction between political, in the sense, broadly, political propositions outside, political campaigns outside, but they all translate ultimately into a legislative activity. And as one of the Joseph Schumpeter, a noted Austrian economist, who said democracy is all about competition into getting people's minds. So therefore, this political activity of getting into people's minds and then organizing, arranging a whole range of political activity, translating them into legislative process. So that's where the connection sometimes will have to be kept in mind. I thought these are important aspects to be to be reckoned. And because in one of the earlier cases, I find either in US or somewhere, the question asked is it the protection, is it a special advantage or a special protection? The distinction is very important. You're not asking for a special advantage, but a special protection. So the dimensions of a special protection will be therefore seen from all these angles, from all these dimensions. Let me now take your lordship through my brief note, which is in volume 9. Lords have that?
It's not, it's not coming. So
It's just a 2-page note. It's there in the. I have a court master. Yeah. Protection in Article 1052 and Article 194(2) is confined only to the work, because it's in the context of the argument that Sita Soren is relates to a business or work or functions of the House. It's only in that regard. It's confined only to the work, business or functions of the Parliament or the legislature, as the case may be. The election to Rajya Sabha is an independent process regulated by a special set of rules and is not a business, work or function of the Parliament. The premises where the election takes place is not determinative of the matter. What is not a function of the business of Parliament or the legislature falls outside Articles 1052 and 194(2). The protection extended in Article 1052 is a part of the larger scheme of protection and immunity to Parliament and its functions. The question is not whether the words "in respect of" should be narrowly read or expansively read. The view of the majority that the nexus between an antecedent conduct and a speech made or vote given in Parliament would be the reason for extension of the protection under Article 1052 stems from the view that the antecedent conduct, right or wrong, shall not affect or weaken the importance of the protection to speech or vote inside the legislatures. The nexus test thus may have the effect of exclusion from any liability, civil or criminal, regardless of the unlawfulness or otherwise of the conduct, which leads to or is connected to the speech made or vote given. This test requires disregarding the nature of the antecedent conduct. All that 197 CRPC, sanction, etc. The nexus test may not be a safe guide. At the same time, the possibility of any hostile or adverse action being taken on an estimation of perception of the speech or vote should also be kept in mind. The view of the minority that an act that precedes the making of a speech or giving of a vote may not at all qualify a protection, regardless of its connection with speech made or vote given, also deserves to be moderated. On a plain reading of Articles 1052 and 194(2), and keeping in mind the need for freedom of conduct of elected representatives, without being exposed to undue and unreasonable actions and proceedings, it can be said that conduct which is otherwise clearly unlawful and unlawful by reason of being proscribed by a statute will not ordinarily receive the protection against liabilities. However, as a matter of prudence and without sacrificing the importance of high ethical and moral standards in the political field, it will be worthwhile to propose an in-house committee of the respective legislatures to be the speech and vote watch, whose recommendation can be the basis for all liabilities. The 10th schedule to the Constitution of India is a parallel. Sri Narasimha Rao is only in the context of a vote given in Parliament. The review by the court be advisedly confined only to the limited aspect and not to any of the larger questions of powers, privileges, and immunities, and perhaps not even to the question of the ambit of speech made in the legislature. I say this so because the speech legislature can have variety of dimensions. Whether you take away the antecedent part of it or not, then one has to explain the extent of the speech which requires protection. Therefore, I thought the speech part of it, in the context of the facts of this case, the speech part of it does not arise at all, even though counsel have advised the court on the entirety of the spectrum of vote and speech. So that's I thought will be the narrow ground on which I had under the court. Watch me then therefore take to the earlier written note where I have a few other aspects. Because if 105 and 194 are as an integral part of the Constitution, the Article 14.
Listen, before I forget. Yes.
Good. But I'm not sure whether, if I read it, I just want to, in conclusion with the line of thought which I shared with the Lordship, I'm not sure whether we need to go that far as to look into the basic structure doctrine or on test this on Article 14, etc. Because I think once the freedom of speech under Article 1051 and 1053, they are the broader aspects of parliamentary, independence and functioning. In that context, 105 is nestled to a different extent. And if that's part of the Constitution, I say it's also part of the basic structure of the Constitution. The freedom of the function of the Parliament, members who elected there, to say that their freedom will be impaired by anything which not dealt with by law, but by any other understanding of the law. I mean, it's going to be a little problematic. Therefore, let us not go to an Article 14 dimension or a basic sector doctrine to look at the relevance or importance of the reading or construction of Article 105. Now, let me complete the reading of this written submission. This is, the first part of it is, of course, confined to the facts of this case, where an argument is that Narasimha Rao would apply, Narasimha Rao need not be revisited. So to just respond to that, I think in my understanding on the facts of this case, where the election to the Council of States happens outside and not a function or a business or a work of the Parliament or the legislature, then Narasimha Rao would not apply. Narasimha Rao is a case where no confidence motion. There's a lot of literature in what exactly the functions of a legislature. Today, it's a wide range of functions. There are even an advisory function. The number of committees that have been constituted by the parliaments across the world, they're truly very exemplary. I mean, you look at the range of functions, Parliament cannot deal with them all over. Because the committees are the alter egos of the Parliament, in one sense of the term. Therefore, the question as to what happens as a conduct or a worker of waste is also important. So the facts of this case, I think that Narasimha Rao would not apply. And if it does not apply, or the asking of the appellant, perhaps Narasimha Rao to be revisited or not, does not arise. Let me quickly read this part of the written submissions. The appellant has sought the protection of Article 194(2) of the Constitution as a ground for discharge from the criminal prosecution launched against us. Neither before the Honorable High Court nor before the Honorable Court, any other contention has been raised as relevant for the purpose of discharge. Full reliance is placed on the PV Narasimha Rao dicta. Therefore, the short question for the purpose of disposal of the appeal would be as to whether Narasimha Rao would apply at all. The question as to whether the appellant has committed any offence at all, solely with reference to the fact, is not a matter for consideration in these proceedings. The question would be whether the conduct attributed to her does not have the color of an offence by reason of the protective clause of Article 194(2). For that purpose, the only matter to be considered will be whether the exercise of the franchise as an elected member of the state legislature for the purpose of election to the Council of States will be speech and vote within the meaning of Article 194(2). The submission that the invocation of Article 194(2) by the appellant is not a compulsion to wriggle out of an act of bribery can in no way as any submission in relation to invocation of Article 194(2). The distinction sought to be made in paragraphs 1 to 3 of the written submission of Mr. Rajaram Chandran, under the heading "The case at hand" is no distinction at all. The speech and vote immunity is an ancient immunity and has been considered to be a shield against the executive oppression or persecution. The long history of decided cases show the relevance of protecting the speech and vote conduct of the elected representatives from being exposed to civil or criminal action. Is the speech and conduct in relation to the manifold functions of the legislature, where the elected representatives participate, that stands protected. In all cases where the elected representative seeks the protective shelter of Article 194(2), the inquiry will be as to whether the speech and vote is in relation to the manifold functions of the legislature discharged as a legislative assembly. Any conduct other than conduct related to legislative function will thus fall outside Article 194(2). For the purpose of disposal of case of the appellant, the inquiry as to what is speech and vote in relation to the manifold functions of the legislature need not be taken recourse for the reason that the process of election to the Council of State is like any other election process and cannot be treated as a matter of business or a function of the work of the legislature. Casting a vote for the purpose of election of members to the Council of State is not to be equated to the words vote given in the legislature in any committee thereof. He submitted that Reliance Place and Pashupati Nath Shukul, Mukul Sonso, Kuldeep Nair is in order. The question is not whether parliamentary privilege immunity has been sought or invoked in the said cases. The statement of law that matters of election, either to the Council of State or of Her Excellency the President or Vice President, are not speech and vote within the scope of Article 1052 and 194(2) will hold good regardless of the context in which the statements have been made. The submission to the contrary in paragraph F, where the appellant, the written submission, is not persuasive. Legislature is a term which is synonymous with legislative assembly, which is a body of persons invested with the power of enacting laws. In the context of parliament, legislature means either house of parliament. In the context of state legislature, it will be comprehend the legislative assembly and the legislative council, as the case may be. The speech and vote expression will therefore relate to the discharge of functions of both the houses. The distinction, if any, between legislature and house of legislature has no bearing on the issue of understanding the speech and vote expression. Whether the governor would be included in the term legislature is no matter relevance for the purpose of delineation of the speech and vote expression. See in this regard so and so. The question again is not one of proceeding on the floor or premises of the House. The question would always be whether the conduct in question is in the context of the business or function of the legislature. All proceeding of all parliamentary committees are recorded the same state as the proceeding in Parliament or state legislature, as the case may be. The question is not the place, the venue of the proceedings of such committees, what qualifies as the respective tasks assigned to the committees and what transpires in the course of deliberation by the committee. It is submitted the conduct of the appellant in relation to the election to the Council of States, not being a conduct relating to the function of the legislature, will not qualify for the protection of Article 194(2). Then the next part of it generally will address the submissions I made, but quickly I run through them. The subject of privileges and immunities of elected representatives is universally found in constitutional documents. Similarly, despite difference in phraseology, protections are extended to speeches that may be made or votes that may be tendered by elected representatives in relation to the conduct of business or work in the legislative body. It would be a tedious and contentious exposure if elected representatives are to defend themselves in respect of their conduct in relation to the work of business of the legislative body. The logic and relevance of the protection is well settled. The question of connection and nexus between conduct antecedent to the speech and vote exercised in the legislative body, particularly when the antecedent conduct may be designated as unlawful or proscribed by law, has been a vexed question. Instances of corrupt or undesirable motives behind presentation of private member bills or working in mainstream legislation have received the attention of honorable courts. In this regard, there are 3 articles which give a complete understanding of what the US and is also in European context. I'll just read a few pages of them, but I don't want to travel through the entirety of these 3 articles. Then paragraph 12, extreme case of submission of bills of expenditure by elected representatives beyond legally sanctioned limits have been found to be beyond the protection of immunities and privileges. Chaitar, so on. Such instances do not present a difficulty in understanding the scope of immunities. conduct falling in such class being otherwise unlawful and with no connection or relationship with the business, function, or work of the legislative body will fall outside the immunity umbrella. The view taken by the majority in Narasimha Rao is a guarded view. It is not that the Honorable Court lost sight of the shades of the opinion of the Supreme Court of the United States in Johnson and Brewster. The opinions of the minority judges will be considered as coming close to the desirability of looking at high standards of conduct of elected members of legislatures and the need for parliamentary intervention in that regard. A brief glance at deliberations and debates across different jurisdictions and the scope of parliamentary immunity and the incompatibilities of the conduct, which is offensive, undesirable, or unlawful, etc., demonstrate the need for raising the ethical and moral level of conduct of elected representatives. Now, then paragraph 15, the question as to whether Narasimha Rao deserves reconsideration may not hinge only on the majority or the minority understanding of the law. While it is highly desirable that the elected members of the legislatures conduct themselves at the highest level of ethical and moral precepts in order as guiding criteria would still be, and desirably so, a matter for parliamentary deliberations. While the desirability of delineating and setting down the principles which may govern the scope and application of the speech and vote clause is not to be doubted, the matter of laying down enforceable norms may warrant a wide debate and legislative intervention, including intervention by state legislatures, having regard to the multitude of functions of legislative bodies, which are both directly and through their committee proceeding. In Keshav Singh, all state legislatures and then all high courts were heard. In fact, probably I should have suggested to the Honorable Court to take recourse to that, but now that the court has convened and we have presented arguments, I only say that in the context of these important deliberations, the norm laying down, importance. I'm open to this.
Anything else, Mr.
This is volume A.
Interestingly, Attorney General has suggested a more functional test. He has steered clear of either the nexus test or the essential legislative functions test. Yes. And it's more a functional test. So broadly, what that would mean is that a third test, which would be a functional test, immunity would extend to speech or acts of voting necessary for the discharge of the duties of a member of the legislature without fear of consequences. So it's more functional that you are really having regard to the object and purpose of the grant of that immunity.
Yeah, that's why I thought that the court is not required to go into the second part of Article 1052. For the
Actually, Article 1052, the first part refers to in Parliament. It uses the word in Parliament. So in Parliament would therefore possibly refer to the physical space of Parliament. The latter part is not qualified by in Parliament. So you publish something under the authority of Parliament. You'll publish it outside. Parliament may authorize somebody to publish something outside, but it's protected.
No, even there in that context, whether
because you are publishing a record of what happened in Parliament. Right? That's why the second part says, the second part of 1052 says,
it includes
in respect of any report, paper, votes or proceedings. So report, paper, votes or proceedings is obviously something which took place in Parliament. So though you are publishing it outside, if it's done by or under the authority of Parliament, it's still protected.
It's beyond any question.
Yes, it's protected.
Therefore,
but the first part says in Parliament.
And therefore, its proceedings also in respect of the Parliament or a committee thereof.
In fact, Article 1051 also says in Parliament. It says in Parliament. There shall be freedom of speech
in Parliament. That's a general, the wholesale proposition.
So in the debate
parliamentary independence is doing what it intends to do, and nobody will say from outside, look here, how did you speak in Parliament like this?
So if a parliamentarian makes a speech outside Parliament, that's not protected. There's no immunity which attaches to that.
No, even The US constitutional law is littered with all those examples of speeches made outside Parliament, outside the Congress. But in connection, that's why the question is whether it is a political activity or a legislative activity. So as a, that kind of a dialogue.
In part as such.
No, we're not concerned.
Because that says no person. So obviously, person is used in contradistinction to a member of parliament. It will include, of course, a member of parliament also. No person shall be so liable. So liable means liable to a court in any proceeding in respect of the publication by or under the authority of either House of Parliament. So if the publication is done by or under the authority of either House of Parliament.
That's completely protected.
And a publication of what? A publication of a report, paper, votes or proceedings.
260 value.
Like the searchlight. One. Transparency.
Thank you. Thank you for your intervention and for assisting us.
Your Lordship, please.
Thank you. Anything else, Mr. Attorney
I
General?
just want to draw your attention to few articles where I thought some reflections seem to be important.
We'll have a look at those articles.
I just give those
Those
references.
two articles which you have referred
I
to.
just give those references.
Yes.
Um,
Just give us the
in
page.
volume 4A, because I also don't propose to go into the question whether on a proper reading or a correct reading of the Prevention of Corruption Act, this question need not be even gone into, because once they fall under Prevention of Corruption Act, nothing else needs to be, inquired into. I don't propose.
Volume 4A page.
Perhaps that is page 550.
And
It's a article of the Transparency International, and I just give the few page references. At page 551,
yes.
where they deal with the whole question of narrow versus wide immunity.
551.
And they also give some, illustrations in different countries. 551, 552, 551, 552, 553, then thereafter at 556.
All right. Any other article?
You mean page 1, index.
Would you like us to look at any other articles?
Just.
Yes, sure.
In the same volume,
Yes.
a distinction between Britain, Canada, and France. France has a slightly different position, not only non-accountability, but also inviolability. So that's a certain important shade of difference. That you'll also find in page 44.
Same volume.
In the same volume. They're all in the same volume.
Page 44.
Page 44. Then next is an article at page 66 in the same volume.
66.
66. Then page 329.
329.
This takes stock of the law in the European Parliament situation. And at page 161 again, it's a publication by the Directorate General of European Parliament. So they virtually look at the European position in various countries. And one is not surprised to notice that the crime part of
Yes.
elected members, it's not something very peculiar to any particular part of the globe. So this, I thought, would probably throw some light on the generality of these issues. And as they submitted to Lordship the question of laying down a norm in reading 194, 105, they have to be.
Thank you, Mr. The SG is going to argue now. Mr. Solicitor, you will.
I'm not going to take more than 20 minutes.
All right, we'll come back at 2 o'clock.
My lord, can your lordship permit me to address virtually, my lord?
Absolutely, yes, no
Right.
difficulty. We are on the hybrid mode. You please feel free, no difficulty at all. So we'll resume at 2 o'clock. And
Yes.
after the learned SG completes, then Mr. Ramchandran, a brief rejoinder from you.
Yes, I'm not going to repeat anything, only one new dimension which may assist you.
But I have one suggestion to the learned AG, that these articles which are mentioned in volume 4A, they don't have the citation. So if you have to cite it, it may be a little
Yes,
difficult.
Mr. Attorney, if you can I just ask a junior after lunch
Yes,
to
yes.
just give us the citation, those 4 articles or 5 articles,
that.
just the citation
We'll do that.
on a separate page of piece of paper. Yes, thank you, Mr. Thank you, Mr. Attorney General.